It's Lisa with Been There, Got Out. And today's guest is Canadian human rights attorney Nicole Biros-Bolton. I understand from what I just learned a second ago that I think she's streaming this live on TikTok, which is really cool. Like I said, she's a human rights attorney from Canada, and we love our Canadians. Let me make sure she can get on properly there. And we'll be on together. I'm not sure, but I think another Canadian might have brought us together. Maybe. Angie, who is also known as Boss Lady TO. I'm guessing maybe. Not sure. Okay, Nicole, I invited you, but it's not coming on. Let's see. I see like a weird split screen, but I can't see you. So let's hope this works. If she can't get on in the next, oh wait, invite me once more. Okay, Nicole, it won't let me do it. Let me try one more time. I'll just say go live. Let's see if it works. Okay. All right, let's give it like a few seconds. Try again. Okay. All right, Nicole, I'm trying. Let's try one more time. Let's see if this works. There's a lot to talk about, and one of the things that I'm very excited is she's going to give some pro se tips. Okay, Nicole, it's saying that you're unable to join. So I'm going to end this live. I'm going to talk to Nicole, and then we're going to try to get back on in the next couple of minutes. Oh, wait. Let's try one more time. She just sent a request to be live. If this doesn't work, we'll try again. Oh, it's working. I can't believe it. The third time's the charm.
I had some sort of security settings, so it wouldn't let me go on until I changed the settings, and then I lost your invite.
No problem. Okay, so I was just saying, well, I'm thrilled that, and you said we're on TikTok as well?
Yeah, so we're on TikTok. I can't get your view on TikTok, but they can hear you and they can see me. So we've got
wonderful. Okay, so one of the things that, Nicole, you and I talked about when we first virtually met was breaking down complex legal systems, because the people in our community often don't understand what's happening and why, and they really struggle, and there's so much fear and overwhelm involved. And so one of the things that we're going to talk about is managing expectations in this sometimes what like rigid legal system. And what I loved that you brought up in our first conversation was how there's ways to think creatively and sometimes use other tips and tricks to get what you need. So we are always into creative solutions. So thank you so much for coming on. And why don't you introduce yourself to people who might not already know you?
Sure, yeah, and thank you for having me. I'm excited to chat about this because, yeah, what I care about most is making the law accessible. So this is a fun chat to have with you, and that we're aligned on that. So yeah, I'm Nicole. I'm based in Hamilton, Ontario, just outside of Toronto. I'm a human rights lawyer here, and I also, before becoming a lawyer 3 years ago, I had a 20-year career as a counselor and advocate for mostly women, but also gender diverse people and children who were fleeing abusive situations. And so I, worked on rape crisis lines. I worked in shelters. I worked with pregnant people who were experiencing violence in the UK. And of course, it's more heightened when you're pregnant. So yeah, I have a lot of knowledge and understanding about trauma and violence and abusive relationships and gender-based violence generally, which really informs my work now as a lawyer. And part of the reason I became a lawyer was to change that system, which is slow, but I do it at a snail's pace.
Well, I mean, we believe that one of the ways to change a system is to empower people through educating them, and that's what we're doing right now. So again, thanks for coming, and I love your background, and especially that you are focused on trauma, because that is such a huge part of not just the history of the community that we're dealing with, but it continues when they enter the legal system. They often are re-traumatized by just the process of what they think is supposed to help them ends up harming them even more. So, okay. So let's jump right into some of the topics that we talked about. What is a demand letter?
Yeah, okay. Well, this is actually one of the creative ways that, lawyers are very well familiar with, but one of the creative ways that you can use something other than the courts to have some sort of effect or get you what you want. I will say that unfortunately, the legal system that operates within both our countries is really prejudicial to people who are not represented by a lawyer. And so what happens, I'm going to tell you what a demand letter is, but even when you write it and send it, I don't know that it's going to have as much power and force as if you had a lawyer send it. But considering that, it's still an option. Also, we can be creative again and think, okay, wonder if you drafted it. You saved the lawyer some time. The lawyer then had to edit it. Of course, they're going to want to review it and send something that they feel comfortable with, but maybe they could then send it on your behalf for a flat fee. But I'll get into that later. First, you need to know what it actually is. So a demand letter is basically a layout of what you've experienced. So I mean, I do it in the context of human rights or employment, which has a lot of intersections with family law. I mean, it could be, for example, you're out of your workplace and you're experiencing gender-based violence outside of your workplace, but it's permeating what you're experiencing at work, and you need accommodations. Maybe you need time off. Maybe you need to come and go at a different time, or work at a different location, or work from home. Those could be requests that you need to make, and your employer's denying you. So the next step, rather than just go, I'm going to take them to court, would be you could put a demand letter together. And the demand letter would lay out exactly what you were experiencing. It would quote the law, and how the law is relevant in your matter, and how it is clear that what you're experiencing is a breach of that law. And then it would say, I'm prepared to litigate this matter. I'm prepared to go to court, but I would like to resolve this amicably, and without resort to litigation. And so to that end, what I would like to see is A, B, and C, and usually there's 4 or 5 demands, whether that's compensation or the specific requests that you're making. It's going to be easier, I think, as a self-represented litigant or person, to get requests and demands that are not financially focused, because I think, again, I think unfortunately you might need the power and backup of a lawyer if you want to get into money, but it is always an option. And that's actually the other thing I should say, is that most lawyers will do demands on a contingency fee basis. If you do have money that you're probably going to get out of it, then you can actually, like, for example, me, I charge a flat rate to write the demand letter, which is on a sliding scale. So it really depends on how able somebody is to pay that. And then a contingency fee. So if you are successful and I do get you money and we settle the matter, then you give me a percentage. But if you don't get anything, you don't pay anything. So that's a way to make it accessible. And I think it's good for people to know that those are options, because even when you're talking to a lawyer, sometimes all those options aren't presented to you. But why don't you ask? Can you do this on contingency fee? Can you do this on a reduced hourly fee? Or, sometimes people do what's called a split contingency, where they do a portion on hourly and it's a really reduced hourly rate, and then a very low contingency rate. So it's a little bit of both. Those are things that you could even present to lawyers and say, I think I have a strong case. I've researched it. This is what I think. Could you do it on A, B, or C? And explore that.
I love this information for a number of reasons. Number one, we often try to encourage our clients to be the proactive problem solver, and that's exactly what this demand letter does. Instead of leaving it up to some third party, I've been wronged, fix it. You are putting in writing exactly what you're asking for and why you're entitled to it. And this is why it's so important. So you talked about quoting the law. We talk about where we are, like case law. You need to look up case law to match it. And I've been at events where judges have spoken and they've said, if you're not getting what you want, make sure you use the law to tell me what to do. So that's exactly what you're saying. So it's almost like either a lawyer can write it on your behalf, and I love, again, that you're mentioning contingencies and flat fee rates and the way that that works, and that people should ask, because many people aren't aware. So it is great to always be able to ask a question, but that you quote the law, like I'm taking all these notes. So you request what you want, you quote the law, so you explain how how your situation is being breached, or how whatever's happening is a breach of the law. say that you're prepared to litigate, but you'd like to resolve amicably, which to me signals to the court that you already understand how much time and money might be wasted, and you're being respectful, knowing that everyone is overburdened by saying, I don't want to go to court, I'm doing everything I can, and then again, asking for very specific relief rather than just saying, fix it for me, figure it out. So you're making the judge's job a lot easier to just resolve it and getting it done. Like, are they going to grant it or not? And we have called this proposed orders, and I don't know if that's the same term you use, even though this is a demand letter. In my own situation, I've done something like this during litigation anyway, and gave it to the judge and said, could you do something just like this? I basically had followed your formula, sort of, and she just signed it twice. So this can be really effective. I'm so glad that that you just answered that question. This is going to really help a lot of people.
Great. Yeah, thank you. And I think too, like, yeah, the orders, that's another thing. I mean, in courts here, they actually like make you come to court with a written out order of what you actually want. And then if decides in your favor, they would sign it. But the demand letter can be like even before you like file an application at court if you're not involved yet. It's almost like an offer to settle, but it happens before you actually take that leap and do it. So it's a good starting point, because if you fail, you can litigate, you can go to court, as long as you're aware of, at least in the context of like employment and human rights and suing somebody, you have to be aware of limitation dates. So how long you have from the point of when something bad happened to when you're allowed to sue, or it's done and dusted and you have absolutely no recourse after. That's
yeah, but what I like that you said was, in order to put this demand letter together, someone's going to have to, whether it's you yourself or you're an attorney, somebody has to quote the law. So in a way, by putting together something like this, you're educating yourself in the law and finding the parameters of what, do you have an argument here? Can you say how your situation's, you know, the law's been breached by what's going on with you? So it's an opportunity.
Yeah, it is an opportunity. And I think beyond that too, if the demand letter doesn't fail, it's your sketched out outline for your pleadings, like what you have to do when you file at court. So that's also a really great thing to remember, is that it's not a lost effort. You can use it to build on.
Love it.
When you have
Love
to
it.
court.
Okay, now tell us, what is perfect evidence?
Yeah, well, I don't know if there is such a thing as perfect evidence, but it's something that has come up with many of my clients when we are in court, where they say, you know, why can't the judge just hear this? Or why aren't you telling the judge A, B, and C? Like, it's clear that this happened. I've told the judge, and the judge is saying that they can't listen to it. It's because we have such strict rules of evidence. What is admissible in court, what is not. The reason that exists is to protect everybody, really, even though it's frustrating. It protects everybody from evidence being, you know, retrieved. For example, the one that we always hear on TV is hearsay, which is a really common one. Hearsay is basically where somebody else told me about something, but I didn't actually see it myself. And sometimes it can be admitted. I know in Canada there are many exceptions to the rule of hearsay, and I'm sure the same is in the States. But what is important for you to remember is that that is sometimes why, and it is the hardest battle when we go through court, is trying to get things admitted. So, I mean, the only advice I can really give, it's really complicated, but look it up, like look up the rules of evidence wherever you are. Again, look to the law, look to case law, because case law, cases and judges are constantly grappling with the rules of evidence and what is admissible and what isn't. And so recent cases in your jurisdiction will show you. And if you can find the right case, sometimes with a really good judge that writes out really beautiful decisions, it actually takes you through step by step, like this is what we need to do, this is how we need to introduce it, this is where it won't apply. And the more you can equip yourself with that knowledge, I think the better, because then you can, you know, present something. But I think it's an important thing to remember when we're going through the court process, that it is a limitation, because sometimes people just get so worked up. Why can't I just tell them this? And sometimes you
again, super helpful. We often see people talking about videos. I took a video. I have all this video of what this person did to me. And I've interviewed Canadian attorneys and American attorneys who say judges generally don't like video evidence for certain things because they don't know, it's out of context. So it's hard. And now with all this fake videos and who knows what people can do, it makes things very tricky. But the rules of evidence are very important. I'm sure you can, it's countless amounts of time people have said, my evidence was perfect, my facts are perfect, and the judge wouldn't listen, and now the system's so corrupt. But it's not necessarily that, it's that you're not following the law, you're not following the rules. And in terms of hearsay, I know I made my own mistake in the past, which wasn't a costly mistake, but I thought that a letter from a therapist or a letter from a doctor would count as evidence, and the judge said, no, we're not going to look at that. But I later learned that anybody could make up a letter. So that person has to be there to testify live. And so we often will tell our clients when they're like, my kid's therapist is going to write a letter, and I'm like, don't count on that going through.
Good point. Exactly. The court much prefers, if they can, to have a witness, because with a witness, first of all, they give their own fresh evidence on the day, but also the other side has a chance to cross-examine, which is testing the evidence and testing the truth of the evidence. And that's a really important part of law. But I also just wanted to pick up on something else you said, which is that, like, as much as it's true that, you know, probably in most cases we are just missing something about the rules of evidence, sometimes it could be that the judge is making a mistake, or the other side has a really good lawyer and has made you feel like thrown off your feet, and so you've just, I don't know, whatever it is. But like in that case, if you really think, no, I'm pretty sure that I should have had that admitted, consult a lawyer, because maybe you have a right to appeal. Like, you don't have to accept everything that is said, and cases get appealed all the time, all the time. That is how law is made and evolves. So just remember that that's sometimes.
Definitely. Okay, there's a question here, which I think I know the answer on. I'll let you answer. What about recorded phone calls with the children?
Okay, well, in the family court context, I can't say for sure, because again, I'm not a family lawyer myself, I'm a human rights lawyer. But here's the interesting thing. I'm not allowed as a lawyer to tell a client to record a conversation. But what I will tell you is that even today, I had a case where I sent a demand letter on behalf of a client who's being discriminated against in her workplace. And she was ultimately fired because of her disability, we say. So I laid that all out in a letter, and the letter came back from their lawyer saying that never happened. She never told us. She never asked for help. Well, my client recorded meetings where it's actually very clear. She tells them what kind of disability she has. She doesn't have to, but she did. She told them, a number of things about that disability and her limitations. She asked for specific help and laid out what she needed. And because of that, we're actually getting a much bigger settlement. So I'm that there. I can't tell you what to do, but sometimes, you know, he said, she said kind of problems, which often come up in any kind of narcissistic situation or violent or abusive situation. Sometimes it's good to have extra evidence if you can get it admitted. And sometimes you don't even get to court. Like sometimes, like in this case, it's just a demand letter. We haven't even started litigating, but because we have such a strong case, they're more motivated.
So it's leverage. Great.
Yeah.
Okay, next, indeed. What is case law on Fridays? You had talked about storytelling.
Oh, it's something that I do on my TikTok. So I facts on Fridays, I call it. But it's definitely the most popular thing on my TikTok. I just review relevant case law. Right now I'm focusing on Canada, but if I mean, there's a whole doozy of cases that are coming out of the States right now that I should probably focus on too. But anything to do with your rights, and that could be in any context. Like I've done a few criminal ones that went to the Supreme Court, and people just are really interested. I think well, first of all, I give you the facts of the case. So it is storytelling. It's hearing about the story of a case and what happened. It brings the law to life, and it tells you what judges are thinking about when they make law. And I don't think people connect that like, oh, the courts are all over here doing stuff. Like they're making law just like the government is making law, and they're interpreting it and they're evolving it, sometimes for better, sometimes for worse. So I think it's it's important, and it's really helpful to review
Yeah,
that.
as
So I
you're
try to
saying
do
that,
that every
I'm
Friday.
thinking things have changed in the world. I know there was a flurry of cases about COVID and vaccinations that was pretty interesting.
Yeah,
So,
absolutely. Yeah, yeah. Same here in Canada. Yeah, lots to do with that. And I did one recently on driving while under the influence and whether you can be stopped on private property to be tested. And it was a really interesting analysis because technically the court said no, but they allowed the evidence anyway because he was so intoxicated that they felt it was in the public interest. So that's also an interesting concept of evidence where there's actually a test in Canada that has been established by a previous Supreme Court case that talks about even though somebody's rights were breached clearly by getting this evidence, it's so important for the public that we're going to allow it anyway. And so he was convicted even
wow.
though
Okay,
the
so,
police made a mistake.
we're doing this on my Instagram and your TikTok. So for any Instagram people who either are watching now or who will see it later, why don't you say how they can find you on, I'll ask you again later, but how they can find you on TikTok to hear this incredible storytelling, which is fascinating.
Yeah, thanks. Well, you can find me on Instagram and TikTok at the exact same handle, which is
Okay.
at empathy
Great.
lawyer,
All
all one
right.
word. Yeah.
So what we also talked about, so we just were talking about how judges interpret the law and how important is credibility and I'll say corruption, because people always will want to say that's corrupt if things didn't go my way.
Mm. Well, yeah, I mean, I think credibility is everything, and judges have the right to assess somebody's credibility based on how they present. And so I think it is really important, and also I recognize incredibly challenging to remove emotion from something that is incredibly emotional and personal for somebody that's like going through, especially a family court matter. I can't think of anything more personal. But remove it. Pretend you're somebody different when you're in front of the judge, when you're answering questions. Keep things short and sweet and simple and to the point. Do not be argumentative, because all of that works against you. It really does. And you read some case law, because you'll see when judges are talking about the case and how they're weighing up this and that, because they have to go through their whole process. They always talk about, well, she presented clearly and seriously, so I take her as credible. Or the opposite. The complainant was incredibly argumentative, and I don't believe her evidence. Those are things that the judge or the decision maker has the authority to make, and unfortunately, I mean, to some extent, they are based on their own internal biases and how they're interpreting what you're doing and what you're saying. I think the other thing to note is that, I mean, often if you're traumatized, sometimes we all display pain differently or symptoms of trauma differently. Sometimes we laugh when we're really nervous, but that might come across as, you're not even taking this seriously. This is no big deal for you. If that's something that you do, say it at the beginning. I'm really nervous, and when I'm nervous, I laugh, but I just want to say at the outset that I'm feeling horrible about this, and I'm feeling really upset. Like, try and be a bit vulnerable and put things out at the beginning that will help you to
So
appear
this
more
is
credible.
so helpful. I mean, part of what we do with our clients is working on presentation. We're not attorneys, we're high conflict divorce coaches, but we talk about how, again, just like what you said, you have to take as much emotion out as possible because the court's not an emotional place. So the goal is to be as calm as possible. And the way to do that is to be really focused and organized. And we often talk about, we want the people that you're dealing with to like you so that they believe you. And if you're hysterical, it kind of corrupts your own facts and evidence, because people don't want to pay attention to somebody that's hysterical or drunk or crying, because it just, people just stop listening. So it's so important to be as level as possible. But of course, like you just said, family court is extremely emotional. Our clients are worried for the safety of themselves and their children and their future, and so it's very, very hard, and it takes a lot of practice, and we do a lot of role playing and preparation.
Which is great. And I think on that note too, is that if you are going to be cross-examined, unfortunately, what a common tactic of a lawyer when they're cross-examining somebody is to go after your, virtue as a person. You're lying. I don't believe you. You're making all this up, aren't you? And if you hear that enough and you're involved in such a deep way, it's very easy to get angry. But that's what they want you to do. They want you to lose your train of thought and to start lashing out. No, you have it wrong, which is very easy and tempting to do. But again, nope, I'm just going to stay cool and calm and be angry.
Yeah, exactly. And
the best
and
approach.
we work with our people all the time saying opposing counsel is going to be a bully. So we already know this is going to happen. They're going to call you an unfit parent, a liar, a drug addict, and that you're mentally ill. So let's just plan for that. How are we going to respond to that? And then practice. Yeah. But people often are so scared because they're like, what if they say this? It's like, they're going to say that. They're going to. So let's just plan for it.
Yeah, that helps. I mean, I think that gives you the power
Right,
and control,
Instead
right?
of getting, because so many people get blindsided and they're like, I can't believe it. And they were saying all these things and I was crying. And it's like, you need to know what to expect before going in. And it's going to be awful, but you can get through it. Like when you know what to expect, it makes things easier because you say, I knew this was coming. This is what I'm going to do. I already figured out how I'm going to deal with this and get through it. And then it's going to be over and I'm going to be okay.
Yeah. Absolutely. My favorite quote, which is Michelle Obama, where she says, when they go low, we go high. I think that's for pretty much every part of my life, but it applies here where like you know what, they're going to go low. They're going to be little stinkers, but you just go high and you leave there with your head held high because you did the right thing.
Right. We always say like the truth is the truth. Like they can do whatever they want to tear you down and deflect from the actual issues or what's happening, but the facts are the facts, and sometimes it takes a while to come out. And sometimes you feel like you've been gut punched, but you go back again and you keep going back and the truth will come out. Just can be expensive too sometimes. Definitely. But okay. All right, let's talk about procedure. How important is procedure?
Yeah. Well, incredibly important. The courts love rules and they have lots of them. They have lots of little rules. And it's actually one of the ways that judges' independence is preserved. So judges, like the head judge of each court, has the authority to set rules and procedures for that court. And so the rules are everything to do from, what forms to file, timelines. Timelines are so important. You miss a timeline and you are out of luck. It is very near impossible to go beyond a timeline and say, well, I made this error or I just forgot. I mean, you would have to have a really severe illness that you would have to prove with medical information to establish that it was reasonable that you missed the timeline, because they're gold. So make sure at the very outset that you note how much time I have until I file whatever it is, how much time I have to reply, how much time they have to respond, how much time I have to, submit my evidence. Usually you have to submit legal documents in advance of the court proceeding. They will tell you those timelines. If they don't tell you to your face, then what you do is you look up the rules of procedure for whatever court you're going to, and you will be able to read everything there. The other thing, at least in Canada, what we call it, I'm sure the States have something equivalent, but every once in a while, the head judge of a court will issue what's called a practice direction. And that basically is like a guidance for lawyers and, self-represented litigants as well, that shows you, okay, we've actually changed one of the rules and this is how we're doing it now. So just make sure that when you're filing, you do A, B, and C. And especially around when COVID hit, a lot of things switched to virtual filing, virtual serving. So just being able to email somebody and saying that service instead of having to serve them with a courier. So just make sure you take note of those. It's incredible.
And when we talked about, I can't remember what word you used, but we often use the word limited scope attorneys, and we will say, even if you're pro se, it might be important to consider hiring a limited scope attorney just to make sure you follow procedure properly, because you are not an attorney, and if you mess up on procedure, you could lose the whole thing.
Good point. Yeah, or you guys have paralegals as well in the state? Yeah, so I mean, that's also an option. They're cheaper, and they know procedures, especially at the lower courts. A lot of paralegals are involved, so that
Yeah.
might be a cheaper way as
Okay.
well.
Let's talk about pro se, self-represented litigants. We have a number of clients who are pro se. Most of them have lawyers, but still, as a pro se myself, I can't wait to hear your tips on being pro se or pro per or self-represented litigant.
Yeah. Yeah, what are my tips? I mean, a lot of what I've said today, absolutely. I mean, I do think the idea of a limited scope attorney is a great idea. Like I do have some clients who even yeah, I guess you call it limited scope. They just pay me an hourly rate, but what they'll do is they'll draft everything themselves. So they'll write out their entire pleading and then they'll say, Nicole, I want you to spend no more than 3 hours reviewing this and giving me edits. And so that's what I do. I review it, I do comments and edits and make suggestions about, you know, maybe you want to focus more on this, this isn't relevant. And then they take it and they fly with it. And, you know, later on in the process, they may come back to me and say, okay, now I have to do this. Can you look at it that way? So I think that's also a good creative way of using lawyers when you don't have the money to have them represent you the whole way through. The other like incredible tool at everybody's disposal is ChatGPT. It is just remarkable. So one of like, here's a few ideas as a self-represented person, pro se, write out what you think you're going to write. Don't rely on it for legal research because it's not always accurate. I've tried, I've tested it. It doesn't always get things right with cases. And if you do get case law from it, always look up the case itself and make sure A, you can find it, it is a real case, and B, that it says what it says. So don't rely on it for that. But what it's great for is helping you with your writing. So what you could do is you could write out everything and then you could say to ChatGPT, hi, you are a lawyer in a family court matter. Here's the context of the family court matter. Be as specific as you can. The other guy's a narcissist. I'm dealing with this. I don't want to come across as this. I want you to write it professional. Therefore, I want you to take this following text and I want you to write it in the form of a legal document. And it's incredible what it outputs.
Wow, I've never heard that.
Yeah.
Amazing. That is amazing. I've never tried it.
Oh, please try it. Try it. It's incredible. It's such a good tool. Like, and again, don't rely on it as like legal advice or even research because it doesn't do all of that. And I think it's only trained up until 2021, so it doesn't have like current law, which is really important. But just for helping you present your ideas and flow,
Wow,
it's really
fascinating.
great.
Okay, any other last tips for pro se or anything else? I see we're getting questions about Kira's Law. I don't know if you want to talk about that. Like, how long will it take for judges to be educated on Kira's Law? I already know the answer to that one, but I'm guessing. But I don't know if you have a comment on that.
Yeah, I mean, well, I mean, I can talk about judges' education, which is, yeah, it's complicated, right? Because judges, again, are independent. And so because of that, we can't like throw things at them, but they do get training. And really it's up to the government to decide what training is mandatory for them. And usually that's in the form of legislation that's passed.
Yeah.
But
I was like, who knows, right? Who can say?
The best way to make sure a judge is educated is to go in there and educate them. Judges don't know everything, and they're the first ones to admit that. Like, how are they supposed to know every law that ever existed? No one does. But what they're looking for from lawyers or, you know, self-represented litigants is a guidance from A to Z, or Z as you say, of the entire law from beginning to end. Here's what the law is. Here's the test that you have to apply, and now I'm applying it to my case, and so therefore I'm successful, right? So you have to give them a map that they can follow, and that's so important. I mean, I guess the only other thing I would say is what's called point first writing, which the law like really needs from you, which is at the very beginning of your paragraph, you're writing what your point is, and then you support it with the rest of your paragraph. I think normally we're trained to do it the other way. We write a bunch of stuff and then we say, therefore, blah, blah, blah. At the very end of our paragraph, flip it. And a good way to do it is after you've done writing, I mean, use ChatGPT, that might help. You could say, write this in point first writing. I haven't tried that yet. So try that. But just print it out. Print out your whole document once you think you're done. And then look at every paragraph, and beside the paragraph, write what you think the point is. Like, what was the point of this paragraph? Some you might not need and you can get rid of them. But for the ones where you're like, this was the point, make sure that's in the first sentence, because if it's not, you should flip it. And that's what judges are looking for. It's much easier to read, and then they'll be following.
So I don't think I told you this, Nicole, but I used to be a high school English teacher, and I taught writing. That's my specialty, and I am a writer by nature and trade anyway. But everything you're describing is about writing and communication and paragraphs. Have a topic sentence. Make sure every paragraph matters. We talk about teaching the hamburger essay, the 5-paragraph essay, intro, conclusion, 3 main points. Each one is the meat, the bun and the meat. So everything has to fit into why you're presenting whatever it is that you're presenting. Everything has to flow smoothly. So this is very hard. I mean, I know you're giving, these are great tips, but often people need assistance from professionals to really go through. It helps to have another set of eyes, someone who's a writer or a teacher or a high conflict divorce coach or a lawyer. Check it, because it's very hard to be neutral. Everything that I write, I read out loud. I go over it, over and over it. I get an audience, you know, like my partner or my dad or somebody to read it, to hear how it sounds. So this is very difficult. Again, like, excellent advice, but people watching, listening know that it's always helpful to have other support to go through this stuff, because this is not easy.
Not in the slightest. And like, I should say, even as a lawyer, like, I take writing courses, because it's hard for us lawyers, it's hard for judges who they take decision writing courses. Like, we're all learning and we're trying to better ourselves. But yeah, the people that are doing it day in, day out, of course, know a little bit more about the style and the important things that you need to remember when you're documenting things. So I agree, like, even if you can't afford somebody for the whole thing, pick your like really important places and points where you need to maybe consult with a lawyer just to get some advice, and then you'll keep costs down that way.
Super helpful. Okay, so any other last things you want to say? And if not, then again, tell us how people can find you.
I think this has been a really wonderful conversation. I think, you know, I recognize that the law is full of barriers, and it's really, really hard to navigate, especially when you don't have representation. But yeah, I will give a shameless plug. Follow me, because that's what I try and do. I try and break down, you know, the different steps, obviously more from a human rights and employment context, but about, like, you know, this is how you present something, or this is how you file an application with the Human Rights Tribunal. And I think a lot of that stuff would be applicable, because it's the stuff we're talking about, like point first writing and taking the emotion out and all of that. So anyway, you can find me at Empathy Lawyer, all one word, both on Insta. I could use the Insta followers, because I don't try as hard on here as I should. So
yeah, well, thank you so much, Nicole, for all of this amazing information. This is so helpful. I've learned a lot. So and I'm going to try like ChatGPT. Oh my gosh, I'll have to dabble in that.
Amazing.
All right. So I'm sure we'll be back together again, but thanks everybody. And again, thanks Nicole, and follow her at Empathy Lawyer on TikTok and Instagram. Okay, bye.
Thanks so much.